The next couple of lectures are going to deal with certain, I don't want to say miscellaneous, but additional issues about trademark eligibility. And one point I've made in an earlier lecture that I want to return to right now is this idea that one of the potential interesting things about delving into any particular area of the law, and trademark law is an example, is that sometimes a deep study of a given subject may be helpful in illuminating certain general issues that run across different lines of doctrine. And so the example that I have in mind today is thinking about the distinction between the content of the rule and the purpose underlying the rule, and what that might mean when you're applying the rule to what might seem a novel or a rather out of the ordinary situation. And so my example here is something known as the personal name rule in trademark law. So at the common law of trademark unfair competition, marks that were personal names required secondary meaning. And that makes sense in most contexts, and we can think of the usual reasons why that might apply. But now think about something like the name Niles for a product that is a stuffed animal that is a camel. Niles is a personal name. People used to watch the show Frasier, right? One of the main characters was named Niles. So Niles is a personal name. Does that mean that Niles the camel can't get trademark protection without secondary meaning? And so now here's where I think it's helpful to think a little bit about what the reasons are for the rule. You want to allow other people who have the name to enter into business without having to worry about your trademark. You want them to be able to identify themselves. Many names are common, and so maybe a name doesn't perform a good source identifying function in conjunction with a person offering goods or services. Many names are common, and consumers may not make a trademark association with a particular use of a particular name when that name may be used by somebody else. Consumers may not be thinking of this as a trademark association if they see the name in another context. Names are descriptive. They provide useful information when available to competitors with the same name, right? This is a product by Joe. Hey, my name is also Joe, and I also provide a competing product. And the Lanham Act limits registration of surnames for trademarks. You actually have to acquire secondary meaning there. So does the purpose of the rule get served in a situation where you're dealing with Niles the camel? And really, no. And in an opinion by Judge Posner in a case called Peaceable Planet versus Thai, the court held that there was no competitive need for Niles for a stuffed camel. Now, contra the word camel, where there clearly is a competitive need and clearly a good reason for withholding easy trademark protection. And in context, Niles for a stuffed camel, right, the evocation of the Nile River, that region of Egypt, is a suggestive mark in context as applied. And the rationale for a personal name rule doesn't apply. And the court actually has in its opinion, we should notice, first of all, that camels, whether real or toy, do not go into business. And so this is an example of a court running into a rule and rather than applying it, automatically, decides instead to interrogate the rationales for the rule and then adjust its application accordingly. Now, of course, there are arguments that say this isn't the kind of thing courts ought to be in the business of doing. A rule is a rule is a rule, and certainty and the like is best served if courts just go ahead and apply the rules as they are without kind of getting into this deeper analysis. I'm not here to engage that debate today. I'm just here to note the presence of that debate and note this interesting instance of the tension between a rule and the rationales for the rule and which one predominates in an actual fact pattern, in an actual application to a novel set of facts. And we'll leave it there. And our next lecture will be talking about the trademarkability of copyrightable subject matter and the Daystar case. I'll see you then.